Good morning, this is your Kelso Report for Monday, October 31st, and I'm your host, Clark Kelso. The parole evidence rule is one of those wonderful doctrines that professors love to ask first-year law students about. When does it apply, and what are the exceptions to its application? Well, the 5th District really had a chance to go to school itself on the parole evidence rule in Duncan versus the McCaffrey group, where the plaintiffs, who are individuals who purchased lots from defendants with the intent to build custom homes on each lot, sued the developers of attractive land marketed as the Treviso Custom Home Development for fraud, unfair competition, and false advertising. The underlying factual story was that the developers assured early buyers that every house in the development would be a custom house of at least 2,700 square feet, while all along the developers intended to build tract homes on some of the lots that would be much smaller than 2,700 square feet. When it became clear that the construction of smaller tract homes was in the offing, primarily because the CC&Rs were amended by the developers to permit homes as small as 1,400 square feet, plaintiffs alleged the value of their lots plummeted. The trial court sustained the defendant's demurrer on the ground that the parole evidence rule precluded any testimony about facts inconsistent with the contract between the parties and the purchase and sale agreement. Because the parole evidence rule barred that contradictory evidence, there was no factual basis for any of the plaintiff's claims. The 5th District affirmed in part and reversed in part. Now, the parole evidence rule generally does prohibit the introduction of either oral or written extrinsic evidence to vary, alter, or add to the terms of an integrated written agreement, although extrinsic evidence introduced to explain the meaning of a written contract is admissible if the interpretation of the contract urged is consistent with the document. The rule is based on the concept that a written integrated contract establishes the terms of the agreement between the parties, and evidence that contradicts the written terms is legally irrelevant. In essence, the written agreement supersedes any prior or contemporaneous negotiations, either oral or written. The defendants argued, and the trial court agreed, that the written agreements with each plaintiff clearly authorized the developers to build homes smaller than 2,700 square feet, and did not require that all homes be custom homes. So, according to the defendants, any oral or written statements that contradicted those agreement terms were inadmissible. The 5th District agreed with respect to the fraud claim. Applying the so-called Pendergrass rule, named after the 1935 California Supreme Court's decision in Bank of America versus Pendergrass, the 5th District held that for purposes of a fraud cause of action, the parole evidence rule precluded evidence that contradicted the terms of the contract. As a matter of policy, the court in Pendergrass concluded that contract principles should be paramount over tort principles in order to avoid injecting tort into commercial transactional contexts where such principles do not readily fit. This is really the traditional contract-tort battle. However, according to the 5th District, the Pendergrass rule did not apply to either the unfair competition or the false advertising claims. The difference was that these causes of action did not attempt to vary, alter, or add to the terms of the written agreement between the parties. Instead, the premise of these two causes of action was simply that the defendants had falsely marketed the properties, and these causes of action were therefore not actions on the contract and not subject to the parole evidence rule. It does seem to me there's a little bit of tension between how the court treats the fraud claim and how it treats the unfair competition and false advertising claim. A lot of that tension goes back to the Pendergrass rule itself, which made a policy choice to let a fraud claim be subject to the parole evidence rule. The 5th District, I think, felt bound to follow Pendergrass in that specific fraud context, but there seemed little reason to extend Pendergrass to the statutory context of unfair business practices and false advertising. Well, now we turn to our one-liners. We begin with a federal habeas case in Boyer versus Belek. The Ninth Circuit affirmed the district court's denial of the petitioner's request for a writ of habeas corpus when the petitioner challenged the sufficiency of evidence of his conviction in Oregon of attempted aggravated murder. The defendant was convicted of some 20 counts of sexual offenses, including sexual abuse, sodomy, and attempted sodomy, all with young boys. The theory of the attempted aggravated murder charge was that he knew he had AIDS, and that he attempted to cause the death of 2 of his victims by performing anal sodomy on them. The petitioner challenged the intent element of the crime, arguing that his intention was only to have sex, and that even if he was reckless with respect to the risk of AIDS transmission, that was not sufficient to establish the intent element of the crime under Oregon law. Both the District Court and the Ninth Circuit recognized their limited role in the habeas context was only to determine whether, as defined under Oregon law, there was sufficient evidence of intent. That determination was quite easy because an earlier Oregon appellate decision had squarely held that a person with AIDS having unprotected sex with others, knowing that the disease could spread this way and knowing it could be fatal, can be held to have satisfied the Oregon substantive element of intent for an attempted murder charge. The evidence in the case before the Ninth Circuit satisfied the elements as identified in that prior Oregon case. So the habeas petition was rejected. Next, a criminal forfeiture case in United States v. Newman. The Ninth Circuit reversed the District Court's decision in 2 separate cases to eliminate or reduce to a trivial amount a criminal forfeiture of assets. One of the defendants had been convicted of robbing a bank, and the other had been convicted of defrauding a bank. This subjected each defendant to a criminal forfeiture sanction, and in each case the trial court ultimately did not order a forfeiture in the amount specified by the applicable federal statute, citing various policy and legal concerns. The Ninth Circuit reversed, because the statutes provided that the court, quote, shall order, close quote, the specified forfeiture, and the court held the plain meaning of the statutes applied. The court remanded for the District Court to enter the specified forfeiture orders. Next, we have a search and seizure case in People v. Thomas, where the Second District held that when the defendant voluntarily deposited his saliva on the mouthpiece of a preliminary alcohol screen device as part of a field sobriety test, he lost all privacy interests he had in that saliva, so that subsequent DNA testing on the saliva, which occurred without securing a warrant, did not constitute any illegal search. The testing connected the defendant to a series of residential burglaries, and he ultimately pled no contest to a single burglary count and was sentenced to 17 years in prison under a plea agreement. According to the court, the DNA test was not a search because the defendant had abandoned any privacy right he had in the saliva when he deposited it on the police device. Next, a Remedies case in the context of forfeiture. In United States v. Wilson, a different panel of the Ninth Circuit than the forfeiture case we mentioned above held that a victim of a Ponzi scheme who gave the defendant $2.3 million and who could trace its money into a specific account held by the defendant where there were no other conflicting claims by victims could recover its money pursuant to a constructive trust under California law, notwithstanding the government's claim that those funds were forfeited to the government. According to the court, the constructive trust under California law attached at the moment the funds were deposited in the account, which is the same time the government's interest attaches. However, the court held that the government's interest, once the property owner had properly established his true ownership interest, is merely in standing in the defendant's shoes. That is, the government's interest cannot be greater than the defendant's interests, and it is clear that the original property holder's interest is greater than the defendant's interest pursuant to the constructive trust. So he got his money back. Next, in the area of civil procedure, in Risk v. Superior Court, the Fourth District affirmed the dismissal of a peremptory challenge filed against a judge as moot, because between the time the litigant, one of several co-defendants, had filed the peremptory challenge and the time the court first considered it, the litigant was dismissed from the case. The Fourth District rejected the argument that a peremptory challenge becomes effective immediately upon filing, noting that the court must first confirm it has been properly filed as to form and time. In this case, With the litigant who filed the motion gone from the case, the 4th District agreed it was moot. Finally, in the area of insurance law, in Clark versus California Insurance Guarantee Association, the 4th District reaffirmed the holding in San Diego Housing Commission versus Industrial Indemnity that costs and interest that are payable under a policy supplemental payment provision are not recoverable by a third-party judgment creditor in a direct action against the insurer. Instead, costs and interest are for the benefit only of the insured and are not intended to benefit that third-party judgment creditor. Well, that's it for today's Kelso Report. Have a great day in the law and a safe Halloween.